Hello, welcome to the MagLife, episode number 167. I'm Daniel Shaw, and I'm here with Adam Kraut. Most of you guys out there will know who Adam is, but I'm going to ask Adam real quick to give us the elevator pitch of what he does and who he is and why you should be listening to him.
Wow. Well, thank you. First of all, I'm not sure anybody should be listening to me, but I am the director.
I feel the same way about me.
My name's Adam Kraut. I'm the director of legal strategy for Firearms Policy Coalition. If you haven't heard of us, head on over to the Google and check us out. We're a very aggressive, grassroots funded organization. We're scared to address any topics, and we're pretty tenacious in the defense and trying to advance the Second Amendment rights throughout the country. Prior to joining FPC, I spent about 5 years litigating Second Amendment issues. You may have heard of me from other things like the legal brief that was on the Gun Collective, something I hope to pick back up in the future.
If you didn't know, now you do. So obviously it's all over the internet, all over the news, everything right now. A lot of folks talking about what happened in the Ninth Circuit today. Obviously, this is the podcast of Gun Mag Warehouse, the MagLife. So there's a lot going on here as we prepare for the potential being able to sell magazines to Californians again, higher capacity magazines than they can normally have access to. That's why I've had Adam to come on, because we found out quite a few things today from our attorney who's on the ground there in California and actually relying a lot on the case that had their ruling on today. And there's a lot of question out there of, can we start shipping magazines to California? So we'll talk about that, but we'll also talk a little bit about what this means, the language, and what this case actually means for the Second Amendment. Adam, you're the expert here. Where do you think we should start on this?
It might be good to just start with what the ruling itself was. Case generally, I'm sure probably most, if you're listening, you're probably interested in it, so you, just in case you're not, Duncan versus Becerra is a challenge that was brought in California. It ended Benitez, who wrote a very opinion at the district court, so the court, the level court and the federal system, where he undertook a very extensive analysis of the law and case law in relation to the Second Amendment, and he wrote a long opinion where he found that magazine was unconstitutional under an analysis to the Second Amendment. So California wasn't going to let that go, and what they did to the Ninth Circuit, if you're not aware, is one of the courts of appeals here in the United States that in particular oversees California states, and it's also the circuit that's most overturned generally with the Ninth Circuit, and call it the Ninth Circus. However, today's opinion was a very well-written, well-reasoned opinion that upheld that law was in fact unconstitutional.
And what does that mean, that this upheld that the law was constitutional? What does that mean for places like Chicago, for other places in Illinois? What does that matter to everybody else in other states, especially the language they used about the scrutiny that they looked at this from?
Practically, it doesn't necessarily mean a whole lot. There are 13 circuit courts here in the United States, and depending upon what state you're in, depends whether or not you fall under its jurisdiction. So I guess for the easy way to explain this, you have a pyramid. Right at the bottom of the pyramid are the district courts. Those are the trial courts for the federal court system. Depending upon what state, there can be one district court, there can be 4 district courts, just depends on how Congress divided that up. From there, if there is an appeal taken either by the person who brought the action or the person who's defending it, so in this case, the state, it goes up to the appeals. The Court of Appeals oversees several different states. So the Ninth Circuit, for instance, oversees, among others, Washington, Oregon, Hawaii, and there's a few others that are in that. The Third Circuit, where I'm at, is Pennsylvania, Tennessee, and the Virgin Islands. So the circuit you're in depends upon which courts fall under that. So essentially is that if your district court is under the Ninth Circuit, this ruling would affect that the district court's analysis there. If, for instance, you're in the Third Circuit, like I am, so say Pennsylvania, The best that they'd be able to point to this opinion, assuming it's not overturned, and we'll talk more about that in a minute, and use it for what's called persuasive authority, essentially saying that we found this is their analysis, this is a correct analysis, and you guys should take that analysis and apply it to this case. It's not binding, which would mean that the court must follow what that opinion is. And then, of course, at the tippy top of the pyramid, you have the Supreme Court, and what the Supreme Court says goes everywhere, except when lower courts decide to ignore what the Supreme Court says, and then the Supreme Court has to eventually come back in and say, no, you got it all wrong. So I guess we'll talk about the scrutiny, since you did mention that, and I think that's something that's worth talking about. In the Second Amendment context, it's a point of contention that I don't think a lot of people are necessarily aware of, is that law in relation to the Second Amendment, and as far as how it's analyzed, is borrowed very heavily from the First Amendment. It's very thoroughly developed. Although it did take some time to get there, it certainly didn't happen right when the Bill of Rights was enacted. It did take some time for these decisions to kind of filter down. So a lot of the courts, truly, that there's a corollary here, the First Amendment, to inform on how to deal with issues. So when we're talking about levels of scrutiny, there are three that are applicable, and depending upon which one you are, higher to get over the hurdle there. So about strict scrutiny. Strict scrutiny is scrutiny that apply in its analysis, and that requires that the government has to have passed a law that furthers a compelling governmental interest, and the manner in which that law controls these things have to be tailored in order to achieve that interest. So strict scrutiny is the highest level of scrutiny that a court can apply when looking at challenged conduct in relation to a company. Talking about strict scrutiny, the law itself has to further compel interest, and it has to be narrowly tailored to achieve that interest. So it can't be just a ban that a bunch of different behavior. It has to be a very fine line to achieve its goal. And if it goes beyond that, then it's not going to be upheld under a strict scrutiny analysis. From there, when you get down into what's called intermediate scrutiny, it's a lesser burden on the government. At this level, it's a important governmental interest, and it has to be done by means that are substantially related to that interest. So here, then at strict scrutiny, where you had compelling, now it's just important. And at strict scrutiny, where it was narrowly tailored, now it just has to be substantially an interest. So this is the level where a lot of the Second Amendment analysis has been happening. And unfortunately, the courts have even been watering down what's required here, which has resulted in a lot of challenged conduct being upheld under so-called intermediate scrutiny, although it would seemingly be arguably close basis. And rational basis is going to be the lowest level, and that's just a legitimate state interest, and the means there has to be a rational connection between the or law and the means and the goals of it. So essentially what Heller said was that under no circumstances is rational basis ever acceptable. The position of FPC when looking at this stuff is not that courts should scrutiny. In fact, we would look at the text as informed by history and tradition. Strict scrutiny, obviously, if the court apply a level of scrutiny, strict scrutiny would be preferable, because that would require it would put the highest burden on the government. However, unfortunately, again, a lot of these courts have been applying intermediate scrutiny. And I think one of the interesting things to see in this realm, when we're talking about scrutiny, is you had Justice in a dissent in versus Kraut recently, within, I think it was back in July, maybe June. He said in his dissent that this two-part test courts have been applying just is seemingly made up and about core Second Amendment rights. So for that, for instance, it's the courts have adopted obviously that part of the core of the Second Amendment is the ability to possess a firearm in your home for of your house. And then they're saying that other things are on the periphery of the Second Amendment, so magazines or the different types of firearms. These are not necessarily core states, but they're part of the Second Amendment. And Justice Thomas has looked at that and said, no differentiation between a core Second Amendment right and a periphery. It's all just the Second Amendment. So they shouldn't be treated differently based on where you courts are seemingly determining that these end up. Going back to the case at hand, and I apologize, that was a long way to get to where we're going here. Going back to hand, the Ninth Circuit at the magazine ban that was in front of them applied scrutiny rather than intermediate scrutiny because it found that the law itself infringed on the so-called core of the Second Amendment that would be able to for use in defense of your home. And itself, the court did say that there was compelling government safety of citizens and safety of police officers and all these other arguments that the forth as reasons for the law. But it also said in the same breath that this was just a broad, flat-out based ban, narrowly tailored to achieve that compelling interest that it has in that. So under strict, the court said, nope, this doesn't pass constitutional muster. It's unconstitutional. And in that same vein, it also went, as a lot of courts do, and applied the analysis scrutiny, and even under intermediate scrutiny, even if that were the correct standard to apply, to still fall short, and thus it can't be found to be constitutional.
I just learned a lot just then, and I'm sure the listeners out there did as well, because I wasn't aware of a lot of the details within that. I think there's a big question right now, since you've explained that and the ruling itself, that I want to know, everybody else wants to know. At Gun Mag Warehouse, our counsel that is on the ground there in California has informed us that the stay by the lower court is still in effect. And until that stay is removed, now he's very optimistic that will get asked to be removed, and it will be removed by the judge. But we didn't know if that was going to happen today or if that will happen early next week. But at the same time, it's likely that California is going to take an action as well. So to maintain a stay in place or another stay, can you explain that a little bit more about kind of what's going on in your personal opinion of it?
Yeah, so when you and I were kind of exchanging messages earlier, I saw an email go out from a website, and magazines could be shipped to California, and here's a list of readers who are willing to do it. And I went, well, I know there's a stay. Let me go look. So, yeah, I'm in agreement with your attorney as far as how that is. Now, I say that as being somebody who's not licensed to California. It's certainly not my legal advice to any retailer that may be listening to this. Get your own counsel. But yeah, the way that stay was originally worded, it was of it on appeal. And as of right now, there hasn't been a mandate issued from the Ninth Circuit. The government, California government, is certainly well within its right to ask for a rehearing or a rehearing en banc, and I'll talk about that in 1 second. And then from there, there's also the possible petition to the Supreme Court, asking the Supreme Court, hey, will you grant this petition to hear this matter and tell us what the answer is? As far as asking to lift the stay, yeah, it's very well possible it could be done. It's also that the judge does, and then the Ninth Circuit imposes a stay pending the disposition of the appeal, or that the government files a request at the Ninth Circuit to stay it, pending of an en banc petition or rehearing petition or cert petition. So there's a number of ways that this could shake out. So as of right now, your interpretation is in fact correct, that as of right now, I believe would in fact be unlawful to ship magazines into California, and that it would be unlawful for individuals in California to purchase all of that stuff that law currently bans. Now, whether that changes, I'll be see that together. As far as the appeal process.
Hey, let me ask something before you get into that, Adam, if you don't mind.
Yep, sure.
I saw one particular retailer out there that said, hey, we're shipping magazines to California, but we take no responsibility for it. Order at your own risk. I hope that our legal counsel is better than whoever's advising that's going to stand up. I'm just curious, like, is that something that, not legal advice, but does that even make sense in the law?
I sure as heck wouldn't be doing that. There's a fairly good argument. I would think that they've availed themselves to California's laws by selling magazines to Californians. It could, be facing the attorney general in California for legal action.
Right. And that's what's holding us back. We did it last time when last Freedom Week happened. We were there. We were early when we saw that, okay, it is fine to sell magazines right now. We increased the magazine capacity of Californians by a extremely large amount. And as far as, it's an economically advantageous thing. That's what we're in business to do. That's what we want to do. Right. But it's also, we believe very strongly in the Second Amendment. And we believe that they've been then robbed of their God-given right this entire time. So we want to support that. But we also want to make sure that not just for fear of litigation against us, but we need to be doing the right thing here. One, for the continued defense of the Second Amendment, but also to protect ourselves and the Californians there.
Well, yeah, I mean, I did mention that they potentially put themselves at risk of prosecution, but really the person buying the mag themselves at the potential for risk of prosecution, because unless that stay is lifted, currently that law is still in effect and you would be violating the law. And if you violate the law, you're looking at potential criminal penalties for California. That's probably not something you want to be looking at if you want to be able to own, and possess firearms and ammunition.
I cut you off when you were about to talk about the appeal process and what you expect to happen. Sorry.
No. It's fine. That was a fair question. So, so as we were talking about with the appeals process, the government still has the opportunity to challenge this ruling, and they can do that by asking for rehearing on the panel. And rehearings on the panel, unless you have a really good reason, are generally never granted. En banc means is literally as the court as a whole, California and the Ninth Circuit anyway. I don't think it's all of the judges on the Ninth Circuit differently. Sometimes it's every circuit judge. Sometimes it's a large group of circuit judges, 10, 11, 12, somewhere in there. So it's going to depend on the circuit as to how many judges actually sit on it. When something's reheard en banc, however, what it means is that the court's going to rehear everything. Their likely argument, again, it wouldn't just be on briefs. And then the court could vary the decision of what the panel came out with. The best example, most relatable that I can come up with off the top of my head would be Colby v. Hogan in the Fourth Circuit to merit assault weapons ban. And in that, the panel came in as, again, a 2-1 decision saying that, yep, this is unconstitutional. And reheard it en banc and came back with, no, this is perfectly constitutional and law. That's unfortunately the law in the Fourth Circuit now, is that they found that to be constitutional. So the very well happened here. It's happened in the Ninth Circuit several times with prior Second Amendment cases. So I would expect, I'm not a betting person, but I'd be willing to wager on this one that you would, at the very position for rehearing en banc, if not en banc review.
What are we missing here about this and what's happening that from your side is important that I would likely not even notice?
That's a good question. I think one of the important things, analysis the court undertook, the opinion was well written. Thought it engaged in a fairly lengthy historical analysis. It did one of the real that it did do. FPC and FPF, so the Firearms Policy Coalition, and then the Sister Organizations Policy Foundation, along with others, a amicus brief that was drafted by our Director of Legal Research, Greenlee. And in that, one of the things that the brief did go over in great detail was this idea of dangerous and unusual. And if we look at case law, dangerous and unusual came up in Catano, which was a case the Supreme Court heard that dealt with stun guns and tasers, electronic arms. And the court in that essentially said that, test here, and it's dangerous and unusual. It has to be both. It can't just be dangerous and it can't just be unusual. And so, it's unusual if we're looking at things through the lens. Well, electronic arms didn't exist, were adopted, and the court said, no. That's you can't just because it didn't exist then doesn't make it constitutionally protected now. And so FPC's brief, spent some time going through that, and the court did a several-page analysis of this idea of dangerous and unusual, and adopted things that were in the brief as far as it has to be both dangerous. And one of the things the court found was obviously that large capacity magazines, or as we call them, standard capacity magazines, are commonplace. Half of all Americans see them. There's millions of them out there, and this idea of them being unusual is just fun and not reality. We even get to the dangerousness aspect of it. It just said they're not unusual. There's nothing else to do here. So that was pretty cool to see Joe's work get adopted by a court in opinion.
What other role did the Firearms Policy Coalition play in this?
So our only role in this case was amicus. We, a friend of the court brief and the amicus briefs, and it's generally speaking in law, not particular to this area of law, but unfortunately a lot of times amicus briefs are just rehashing things that are found in the briefs of the parties themselves. The whole idea behind a amicus brief or a friend of the court brief is to bring other material to the court's attention that the parties themselves either couldn't fit in theirs because of page limits, word limits, things like that, but to give novel things for the court to look at. So that's one of the things we strive to do, is to keep arguments that the parties aren't making and bring them to the attention of the court as to look, here's some additional information that you might, but that was FPC's role in this case, was as an amicus to the parties.
I've been following the FBC for a while now, and I like a lot of things that are going on. And we obviously have some issues with some lobbying organizations and some things happening in the firearms community. And we have some eating of our own, which we have for a long time in the firearms industry. And not even just the firearms industry, but the Second Amendment. For people who support that, we have a lot of negative things happening. And, I'm just curious how the FBC is addressing maybe moving forward, trying to do a better job than maybe what's been done in the past, and why a listener out there should be thinking about supporting you.
That's an excellent question. So one of the things about everybody who works at FPC is that as far as values are concerned, we're all on the same page. We're all aligned in our values. And that's one of the things I think that drive the organization, is that we all see things through a very similar lens. And when it comes down to our beliefs and stuff like that, we're all on the same page. One of the really kind of pride and the way we kind of market ourselves is, here's our work. And if you like what we're doing, we'd really love your support. And if you don't like what we're doing, well, then we're not going to beg you for money, but we really hope to deliver value to the individual. We try to do that through litigation, through education, through related things. So we're really trying to look at what gun owners and provide value to them, and we hope that in return for providing value, that will join and support us. And that's really it. It's as simple as, if you like what we're doing, cool, we'd love for your support. No, well, we'll get there someday. Let us know what you think we're doing wrong.
So you said something to the effect of, we're not going to beg you for support. So you're not going to send them a DVD and then the bill for the DVD? You don't have to answer.
I'm not involved in the marketing department. But last I checked, we didn't have a video crew that was making DVDs. It's 2020, so well.
Adam, seriously, tell folks where they can follow you out there and hear your insight, and with the FPC and you personally and all the things that you do. And you've been a wealth of information and really helped out a lot. And I'm sure people that are hearing you for the first time that are paying attention, and I hope everybody is, because we're coming up to some crucial times here. that they do hear, continue to hear a good solid voice of reason out there that's grounded in fact and not internet and gun store cliches.
Well, if you're interested in Firearms Policy Coalition, and I certainly hope you are after listening, check them out on the web. The website for it is going to be firearmspolicy.org. If you are one of those people that hops on Twitter, Instagram, Facebook, anyway, or gun policy, so at Facebook, if you just search Firearms Policy Coalition, you'll find us there. I'm sure we're on some other social media platforms that I don't dabble in because, hey, I'm getting old at this point, so I don't know what the kids are up to these days. If you have an interest in following me, you can find me on Facebook, The Real Adam Kraut, and it's the same on Instagram at The Adam Kraut. And I think it's, although I don't really hang out there, but from time to time I'll jump on there. So if you're interested in seeing more of what I got to post.
Adam, thank you for taking some time out of your Friday evening to come on here and talk to us and educate me and everybody else out there. And as things develop, would love to have you back on and talk some more about it.
Hey, it was my pleasure. Thank you so much for the opportunity. And, I'm happy to bring some of the gang here to education from different perspectives. We got a few people.
Oh, that would be awesome. For sure.
Yeah, we got a few people in the roster that I'm sure we could get on here.
Oh, that'd be great. Also, guys, hope you got what you were looking for out of that episode. And until next time, the MagLife out.